Madam Speaker, I rise today in support of Bill C-6, an act to amend the Citizenship Act. During the time leading up to the election on October 19th, I heard many concerns from residents of Cloverdale, Langley City about the changes that the previous government had made to the Citizenship Act. And since this government was elected on October 19th, with part of our election platform being to make changes to the Citizenship Act, I've heard from many citizens and constituents inquiring when these changes will occur. This bill represents an important reminder of this government's commitment to a diverse and inclusive Canada. It recognizes the contribution that new Canadians make to this great country each and every day. The proposed changes in Bill C-6 will provide greater flexibility for applicants trying to meet the requirements for citizenship. It will help immigrants obtain citizenship faster, and it will repeal provisions of the Citizenship Act that will allow citizenship to be revoked from citizens who engage in certain acts against the national interest. And I can tell you, Madam Speaker, that citizenship is an issue of critical importance to my constituents in Cloverdale, Langley City, many of whom are immigrants who have achieved citizenship and are exceedingly proud of their status as Canadians. They're proud of what being a Canadian means for them and their families. Madam Speaker, I've heard from recent immigrants about their fears of losing their Canadian citizenship. They saw how the rules of citizenship could be changed by the stroke of the pen of the government. Members of diverse communities were horrified, even terrified, that they would be targeted for deportation by their own government. In May 2015, under the previous government's Strengthening Canadian Citizenship Act, legislative changes were created to allow citizenship to be revoked from dual citizens. The legislative changes allowed citizenship to be taken away for certain acts against the national interest of Canada. Convictions of terrorism, high treason, spying offences, or for membership in an organized group engaged in armed conflict with Canada were grounds for revocation. Citizens felt threatened and under attack by these changes. I also heard from Canadians who have been Canadians for decades, but still hold citizenship from other countries and pass this dual citizenship on to their children. They too were horrified, even terrified, that not only they, but their children could be targeted for deportation by their own government under the rules set by the previous government, a Conservative government. Bill C-6 repeals these grounds for deportation. This government believes that the Canadian justice system is fully capable of administering justice, protecting the public interest, and holding individuals accountable for their actions. However, the value, the strength, and the iconic symbolism of Canadian citizenship remains intact under Bill C-6. The bill continues to provide the ability to revoke citizenship when it was wrongfully obtained. False representation, fraud, or by knowingly concealing material circumstances remain as grounds for revocation. Bill C-6 also contains provisions to repeal the current intent to reside requirement for citizenship. The previous government's legislation required adult applicants to formally declare that they intend to continue to reside in Canada after being granted citizenship. This has created great concern among some new Canadians. They fear that their citizenship could be revoked if they move outside of Canada, regardless for the rationale for moving. In light of today's global economy, we require flexibility in the movement of our citizens around the globe without the threat of losing the highly desired Canadian citizenship that we all cherish. This government respects this right to move outside Canada, which is guaranteed under Section 6 of the Canadian Charter of Rights and Freedoms, and is something that all Canadians should be allowed to do without fear or repercussion. Another proposed change in this bill is a provision to help immigrants achieve citizenship more quickly. Currently, the Citizenship Act requires applicants to be physically present in Canada for 4 of the 6 years immediately prior to applying for citizenship. Our government is proposing to reduce this time. Prior to submitting an application for citizenship, an applicant would be required to be physically present for 3 out of the preceding 5 years. Essentially, applicants can apply 1 year sooner than they can now. This offers more flexibility for immigrants who may need to travel outside of Canada for personal or work reasons. Furthermore, Mr. Speaker, since the first Citizenship Act of 1947, citizenship applicants have been required to have a reasonable knowledge of English or French. and an understanding of the responsibilities and privileges of citizenship. But the previous government's changes to the Citizenship Act, expanding the age range of applicants who must meet the language and knowledge requirements from those aged 18 to 54 to those age, those aged 14 to 64. This added an additional 14 years to the age range affected by this language requirement. Our government is proposing to reinstate the former age requirement, eliminating a potential barrier to citizenship. For younger applicants, learning English or French and having an adequate knowledge about Canada can be achieved through schooling. For those in the older age group, language skills and information about Canada are offered through a wide range of integration and community services. And all applicants between the ages of 18 and 54 would still be required to provide evidence of their ability to understand and converse in English or French. Similarly, they'll continue to be required to pass a knowledge test about Canada, which requires applicants to have a firm understanding of the responsibilities and privileges of citizenship, with a slightly lesser focus on the War of 1812 than currently exists. Mr. Speaker, I heard from immigrants who arrived in the 1970s and 1980s. I heard over and over again that they don't consider themselves hyphenated Canadians. They consider themselves Canadians, as do I. They were horrified and terrified that they could be targeted for deportation by their own government. This government wants that to change. A Canadian is a Canadian and will always be a Canadian under the changes proposed in this bill. Mr. Speaker, our government is proposing to make it easier for immigrants to build successful lives in Canada, reunite families, and help strengthen the economic foundation to the benefit of all Canadians. Bill C-6 will credit time spent as a non-permanent resident towards the new 3-year physical presence requirement for citizenship for up to 1 year. This proposed change will allow any person authorized to be in Canada as a temporary resident or a protected person to count a day spent in Canada as a half day towards meeting the physical presence requirement for citizenship. Last week, I spoke with an immigrant about the anticipated changes to the Citizenship Act. This woman has been in Canada for 4 years, 2 years as a student and 2 years on a work permit. She's committed to Canada and to becoming Canadian. She was happy to know that some of her time spent in Canada will now count towards her citizenship requirements. As in the case of this woman, the time credit will encourage skilled individuals to come to Canada to study and work, and benefits groups like protected persons and parents and grandparents on visitor visas. Mr. Speaker, I can also confirm that the changes proposed by Bill C-6 will not compromise the security of Canadians. In fact, there are several provisions in this bill that strengthen the fair application of the right to become a Canadian citizen and provide protection against abuse of the process to do so. For instance, the Citizenship Act currently prohibits a person under a probation order, on parole, or incarcerated from being granted citizenship or from counting that time towards meeting the physical presence requirements for citizenship. However, these current prohibitions do not include conditional sentences served in Canada, that is, sentences served in the community with conditions. As a result, an applicant who is sentenced to a conditional sentence order could conceivably be granted citizenship or could count that time towards meeting the physical presence requirements. The amendments in this bill would change that for both new applications and those still being processed. Another provision relates to the requirements to maintain the conditions for citizenship until taking the oath, which I might digress, will respect the court's decision on appropriate attire. Under provisions of the previous government's Strengthening Canadian Citizenship Act, applicants were not permitted to take the oath of citizenship if, in between the time the decision to grant citizenship and the time to take the oath, a period that's typically 2 to 3 months, they no longer met the requirements. Mr. Speaker, let me make one last case. At present, citizenship officers do not have the authority to seize fraudulent documents. Bill C-6 will change that. Mr. Speaker, I remind the House that one of the most effective tools for achieving successful integration into Canadian life for Canadians is by achieving Canadian citizenship. This bill ensures that any and all who become Canadian citizens are treated equally under the law, whether they are born in Canada, naturalized in Canada, or hold a dual citizenship. Thank you.
Questions and comments?